ଅଜୟ ଆମ କଥା ନୁହେଁ ମୁଁ ଯିବି ଚାଲ ତା ଘରକୁ ଯିବା ଅଜୟ ତା ପାଖକୁ ଯିବା ଚାଲ ନାଇଁ ନାଇଁ ସେ ଆମେ କିଏ ଜାଣିବା ସବୁ କୁହା ଚାଲିଲା ମହାଗାଲୁଆ ମୁଁ ତ କହିବି ମୁଁ ଦେଖିଛି ହଁ ସେମିତି ଯିଏ ଗାଲୁକୁ ଗାଲୁ ମୁଁ ଦେଖିଛି ତୁ ଦେଖ ମୁଁ ଦେଖିବି ହଁ ସେମିତି ଆଜି ଗାଲୁ ଗାଲୁ କରେ ମୁଁ ଦେଖିଛି ସେ ମୁଁ କେହି ଦେଖିନି କେହି ଦେଖିଲା ବେଳକୁ ତ ଫଟୋ ଦେବା ତାପରେ ତାପରେ ସେ ଯାଇକି ନାଇଁ ଏଇଟା କହ ସେଇଟା ରଖ
We are now invite the Vice Chancellor of National Law University, Odisha, Professor Ved Kumari, to deliver the welcome address.
Good evening to everyone present here. My special welcome to Justice Bannerjee, who has been an inspiring woman judge, speaking and focusing on the women's health. And my special bond is because of that reason also to Justice Bannerjee. Very hearty welcome to you, ma'am, here among us. And we are privileged to continuously host this memorial lecture. And I feel privileged to be part of this series of lecture. As I just mentioned that I'm very interested in women's work, women's positions, etc. And I feel very nice to think about it that usually we say behind the success of every man there is a woman. It's true for the other way around also. Behind the success of the men are also the men who support them in their households. And in this case, the lecture actually was instituted by her husband, who is no more now. He succumbed to COVID, unfortunately. Otherwise, he has been here in spirit. And also, celebrating women and their achievements is very rare. Women has been achieving a lot, but it is not every day that the men celebrate their achievements, especially their spouses. Because there seems to be a competition. The women should not get more name than their husbands. But in this case, that complex wasn't there. Secondly, I didn't have the opportunity to meet either of the two famous personalities for today's Pujari, but I've met the three lovely daughters. Two of them I've interacted more, the third one not yet. And also, so for me, celebrating the womanhood in Mr. Govardhan Pujari's life seems to have been an important one. He has supported, I'm quite sure, his daughters in all ways for them to have reached the pinnacle of their careers they have. So not only Mr. Pujari and Mrs. Pujari were, apart from other things, poets, the eldest daughter is also one. Not only Mrs. Pujari was good at her, she was first woman to achieve many things with a legal lawyer, woman legal lawyer. The youngest is also there, and the third one is no less behind. The second thing is it's a family which comes together and celebrate each other. And I think it's very important bonding of this family. And that is what we celebrate when we celebrate Mrs. Sailabala Pujari. I welcome you all to this. There are lots of High Court judges. My special thanks to all of you to have raised this occasion and be part of this conversation. And all other guests, in addition to my colleagues and my students who are here to Justice Bannerjee today. And I'm quite sure that there will be relationships we can forge within our families on similar lines and celebrate everybody's achievement, be they men, be they women. With this, I again welcome you all to this, and thanks the family for giving me the opportunity to be part of this important memory and celebrating women lawyers, especially in the name of this Mrs. Sailabala Pujari. Thank you very much, and welcome on God's day.
Thank you, ma'am. May I now invite our esteemed guest, Ms. Indira Pujari, Advocate, Supreme Court of India, to introduce us to Srimati Sailabala Pujari.
Good evening, everyone. I'm carrying 3 pages about Mrs. Sailabala Pujari, who happens to be my mother. I carried more than 65 years of her life together like this. We held each other very tightly till the last. So it's actually a daunting task for any child to give an introduction about the parents. More so when both of them are not there. But I'm sure they're watching all their children, how they are doing, and whether the lessons that they have taught us, they're able to carry forward or not. With that, very briefly, to talk about my mother, like any other lawyer would say, that keeping in mind the sensitivity and the complexity of matter in mind, I will try to make it brief. However, the overwhelming emotional connotations that would come, kindly bear with me for that. Mrs. Pujari was born in 1948 at Shimla to a renowned geologist, Sri Ganesh Prasad Annapurnara. She was named Sailabala because she was born in Shimla, so literally the daughter of the mountains. She was a student leader and was president of the Sailabala Women's College and was considered a formidable voice for student movement in Orissa. In fact, as of today, while I was in High Court, somebody from behind came and reminded me of the student movements of 1960s and 70s and how my mother had played an important role there. It's quite heartening to listen to those stories even now. She was active in social work and took special interest in working for the manual scavengers of Cuttack. Why I mention this is for the reason she came from a family, a Brahmin family of Barampur. And coming from a Brahmin family of Barampur and working in the slums amongst the manual scavengers was quite a non-routine thing, so to say. And it was considered a taboo. But especially in those days, it was radical. However, routine was never her norm. That was never her part. There are many deviations, many non-routine things that she chose to do during her lifetime. On completion of her LLB degree from MS Law College, Cuttack, she shifted base to Rourkela post-marriage with her husband, Sri Govardhan Pujari, who was also an advocate. That move was considered as an aberration those days. She chose to marry somebody from the Western Odisha, and those days the divide between the Western Odisha and Eastern Odisha was quite wide. Keeping the social-cultural scenario in the 1970s, that step itself was quite rare, so to say. In fact, they both chose to shift to Rourkela, which was not that developed as it is now. And instead of continuing to stay in Cuttack, where she had already attained some name and fame. By choice, they both decided to go back to a place which was tribal dominated to contribute meaningfully to people's life. With that mission, they both decided to go back to Rourkela and start their work. Again, unlike the routine, where it is generally the man or the father-in-law or the husband who has a law chamber and where the wife or the daughter-in-law subsequently joins the profession from the comfort of their home, keeping the flexibility that is required. It was very unlikely that, because my mother was the one who was senior in the profession. So she really started the profession in Rourkela. And my father subsequently joined her chamber. if I can say that with a lot of pride. So my father was the junior to my mother, and they never had any clashes, no ego clashes or professional clashes at all that I have never witnessed. And those of you who have met them personally would know it better. In fact, she started her law practice in 1975 at Rourkela and became the first woman in the entire Western Odisha to practice law on a regular basis. She became the additional public prosecutor. Being the only woman in the bar, I would only share one or two anecdotes. It was quite challenging for her to, take care of three daughters and practice because there were no bar rooms. There were only trees and there were verandas. So I very clearly, vividly remember all three daughters. We were carried to the court and we were made to sit in the verandas or under a tree. And she would go and conduct the cases because being an APP, she has to be there in court. And then we will be taken care of by the system. And why I'm narrating this story is this very experience, the lived experiences that matter a lot. Because when I joined the Supreme Court bar to practice law, I realized again, although there was a bar room, there were trees as well in the Supreme Court lawns, but the children's entry was prohibited. So I had no option. My mother's struggle I had seen, so I was forced to file a public interest litigation in my own name. So it is Indira Pujari versus Supreme Court of India, wherein I asked for a creche to be established so that the lawyers, the registry staff, the litigants, everybody can access. So the pain that two generations had gone through, that had to go. So there was some beginning there. So that story of my mother stayed with me. Besides that, she was in fact a pioneer, so to say, in many things, because she was the only active women lawyer in the entire district, in the entire Western Odisha. So whenever there was a new enactment, so the few enactment that immediately comes to my mind is the Consumer Protection Act. So when the law was enacted, there has to be a member from the society. So my mother was picked up. She used to travel from Rourkela to Sundargarh. Those days in bumpy roads on a bus, state bus, and she would attend the proceeding every day and then she'll come back. Similarly, when the JJ Act came, Act came in, she was appointed as an observer so that she would inspect the hospitals, which she again continued for many, many years. She was also the visitor to the Rourkela Special Jail as well as the observation home that's there for the juveniles at Rourkela. And no celebration at our home would be complete without first sending sweets to the observation home. So I've got vivid memories of jail, the special women's ward, as well as the observation home as a child, where my mother was a visitor and she took her job quite seriously. Besides that, she was also associated with a lot many associations, and she was on the legal advisory board of many organizations. She was also legal advisory committee of the Women's Commission, member of the district legal aid committee, amongst many other committees and commissions where she was included because of her expertise in law. In fact, one of the, again, another connection, when the Vishaka guidelines were laid down, once again, she was inducted in the GSIC committee. And that's also the connection between me and Justice Bannerjee, because I'm also an elected member of the GSIC of Supreme Court, where Justice Bannerjee was heading it. These are memories that goes back generations. And these are moments that leaves its imprint on our mind. So these are not small tasks, so to say, where she was assigned a task and she did it. She did it in a way that it left an imprint on us. Besides being a lawyer, she was also, she didn't really bother for the fees. In fact, the hard quote unquote advice to us when I joined the profession was, those who pay you the fee, please do extremely, do hard work for them. But those who don't pay, put much more effort, because that means they really want you and they deserve attention. So therefore, she was at home, she would constantly have women and children as visitors, those who would be requiring help. In fact, she was also in 1980s, I clearly remember, had given representation for establishment of one-stop crisis center that we are talking about today, as well as shelter home for women and children in Rourkela, which although did not happen during her lifetime, but I'm sure with the Supreme Court intervention, it has now happened in many more places. As a lawyer, her zeal to fight never died really. I still remember just a few days before her death, she filed a defamation suit when there was a fight between the lawyers and the police in the state of Odisha. And on a wheelchair, she went to the court, swore her affidavit, and she appeared before the court in Raurkela, civil court. She also founded Swayamprabha, where she believed in celebrating sisterhood, as our Vice Chancellor ma'am rightly said. And she in fact therefore instituted an award called the Swayamprabha Samman, where she would felicitate women achievers so that she can contribute towards encouraging more and more women to make life better for others. She in fact authored more than 50 books, including many on law. She believed that the language of law should be simple, and therefore she wrote many law books in Odia, which are not beyond 20-30 pages, so that she is able to explain the law in simple language to the common man. She was also in the governing council of many colleges, as well as university nominee in many committees. She features as one of the women architects of the women rights movement in the post-independence Odisha, curated by the National Alliance of Women. She instituted many awards to encourage people. She was to put it in brief, she was a true karma yogi. She led her life dedicated to humanity without bothering whether the path that she's taking is known, it is smooth, or it is bumpy and uncharted. This in brief is Sailabala Pujari for you, a life of absolute courage and conviction. Thank you so much.
Thank you, ma'am. It is now time for the lecture by Honorable Justice Indira Bannerjee, former Judge, Supreme Court of India. Honorable Justice Indira Bannerjee is a distinguished jurist with an illustrious career in the legal field. She has served as a judge in the Calcutta High Court, Delhi High Court, and later in Madras High Court before being elevated to the Supreme Court of India in August 2018. During her tenure in the Supreme Court, she delivered several landmark judgments that have far-reaching implications. We are fortunate to have Honorable Justice Indira Bannerjee with us today to share her insights on constitutional vision of justice and the role of judiciary in India. It is indeed my privilege to invite Honorable Justice Indira Bannerjee to deliver her lead.
Gracias. Professor. Professor Kumari, Vice Chancellor, Ms. Indira Pujari, Advocate, Supreme Court of India, my distinguished brother judges of Orissa High Court, and are there any sister judges too? Oh, yes, of course. And especially my sister Judge, Advocate General of Orissa, and other distinguished persons, the distinct members of the family, distinguished faculty members, and last but not the least, the students for whom I am here, in whom I see the future of the Indian judiciary. As you know, when we talk of the Indian judiciary, it's not just the judges. The judiciary means the judges, the lawyers who assist the judges, and others associated with the judiciary. And speaking for myself, I can say that the best judgments came when there was good assistance from the lawyers. It is a privilege for me to be here this evening delivering the Sailabala Pujari Memorial lecture. She was not just an outstanding lawyer, the first woman lawyer of Western Orissa, but she was a multifaceted personality, an outstanding woman. And on Indira missed out. She was also a literature and a poet who wrote poems. In those days, it must have been extremely difficult for a woman to make a breakthrough, and she did it. She involved herself in human rights, in protecting the human rights of scavengers, manual scavengers, and other oppressed persons in society. Women have always faced some difficulty, and sitting here in the presence of the Advocate General, I feel very nostalgic because I'm reminded of Mrs. Sailabala Mukherjee, our beloved lady. I think she herself was a victim of gender bias, or else she would have made it to the judiciary. The loss was not hers, of course. The loss was that of the judiciary. And I still recollect that on 5th February 2002, the day I was elevated as a judge, Gopal, Mr. S.N. Mukherjee, the present Advocate General, he went to Delhi at that time. Again, Joloda, Mr. S.B. Mukherjee was a minister in Delhi. And the first thing we asked was, how is Indira looking on the bench? I wanted to go and visit her, but unfortunately, just 2 days later, on 7th February 2002, she suddenly passed away. Anyway, these are memories, but I think the vision of the Indian Constitution is an apt topic, considering the life and the contribution of Sailabala Pujari, and of course, the role of the judiciary as well. I do hope that the students sitting here today will contribute to the justice delivery system in one way or the other. I hope some of you join the judiciary, and I see amongst you my successors in office in future.
I may not be there to see you, but I'll be happy to join and contribute to the judiciary. The Indian Constitution, as you all know, is that basic document on which the pyramid of the Indian polity rests. We have a people-centric, egalitarian constitution. And since we are talking about women, I would also say it is a woman-friendly constitution, because all the rights are equally available to all, including women. And there are provisions in Article 15, sub-Article 3, for making special laws for women to set right along prejudice, gender prejudice that has prevailed. On 26 November 1949, the people of India, having resolved to constitute India into a sovereign democratic republic, adopted, enacted, and gave to themselves the lengthiest constitution in the world, consisting of 395 articles, divided into 22 parts. Two more schedules were later added. The constitution underwent several amendments, which we need not discuss just now. The concept of a constitution in the name of the people, defining the powers of the different organs of the Indian polity and delineating the relationship between them and also between the government and the citizens, emanates from the principle that individuals have natural rights which are inherent and inalienable, which existed long before any written instrument like the Constitution was thought of. The government acquires its authority from the people, and that the purpose of government is to promote common good. The state emerged because of the advent of democracy and a limited government and the governance between citizens. The idea of an organized state was to maintain peace, law and order, for improvement of the people in general. A written constitution like ours empowers the citizens. It limits power and protects liberties. As Lord Acton had said, power corrupts and absolute power corrupts absolutely. A written constitution like the Indian Constitution unfolds a vision and a goal and chalks out the path for its realization. The preamble to the Constitution summarizes the aims and objects of the Constitution. The people of India, acting through their representatives in the Constituent Assembly, enacted, adopted, and gave to themselves the Constitution, which promises to secure to all justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote amongst all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. The preamble was amended by the 42nd Constitution Act, with effect from 1976. And then Sovereign Democratic Republic was amended to read Sovereign Socialist Secular Democratic Republic. And also, and integrity was added after unity. But these amendments didn't really make much change except to emphasize, because we have from the very inception had a socialist polity which believed in equalities, which believed in social equality, economic equality, political equality, and a secular constitution because it guaranteed freedom of faith, freedom of religion, so on and so forth. The vision of our constitution is to be found in its preamble and also in parts 3 and part 4 of the constitution, containing the fundamental rights and the directive principles of state policy. The fundamental values and principles on which our constitution is based are embodied in the preamble. The words used in the preamble of our constitution are some of the noblest words. They embody the highest values. The preamble is the key to the minds of the framers of the Indian Constitution, as observed by the Supreme Court in the Bannerjee case. However, Justice Garendra Gakkar said that the preamble was not part of the Constitution. Also, it did not confer any substantial powers to the legislatures or other organs of the state. These must have their source in express or implied grounds by substantive provisions of the Constitution. Now, observations actually hold good even today, except that the principles in the preamble are now accepted to constitute the basic elements and/or basic features of the Constitution, evolved in later on in Kesavananda Bharati. Yes. And these basic elements and features were held to be unamendable. In Sachin Singh versus the state of Rajasthan, Justice Madhurkar said that the preamble had the stamp of deep deliberation, was marked by precision, and the framers of the Constitution attached special significance to it. In Golaknath versus state of Punjab, Justice Hidayatullah observed that the preamble to the Constitution epitomized principles on which the government was to function. The preamble was the very soul of the Constitution. The scope of the fundamental rights guaranteed in Part 3 of the Constitution and the directive principles of state policy can be better understood in the light of the objectives enshrined in the preamble, as held by the Supreme Court in one of you will be able to help me out in the Mysore case of 1970. Bharti Chandra. Anyway, that is what the Supreme Court has held. I'll give the exact reference later. In Kesavananda Bharti versus State of Kerala, the majority referred to the Constituent Assembly debates, revised Justice Gajendra Gatkar's view and held that the preamble was part of the Constitution and that observations to the contrary in Delubari Union were not correct. The preamble, in fact, contained the basic features of the basic elements of the Constitution. Justice Sikri said that the legislative history of the preamble to the Constitution justified its importance. The preamble was not only very much part of the Constitution, but it was of extreme importance, and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. In Keshavananda Bharati, the majority held that any provision of the Constitution could be amended under Article 368, but within the broad contours of the preamble. The Supreme Court held that the inalienable basic elements of the Constitution could not be amended so as to alter them. The inalienable basic features of the Constitution were thought to be traced from the words of the preamble. So the preamble is now considered to be an inviolable part of the Constitution and assumes a special position as an aid to interpreting the Constitution. In Bommai versus Union of India, Justice Ramaswamy said, the preamble of the Constitution is an integral part of the Constitution. Democratic form of government, federal structure, unity and integrity of the nation, secularism, social justice, and judicial review are basic features of the Constitution. To sum up, the Indian Constitution, as it stands today, after the 42nd Amendment, envisages India as a sovereign, socialist, secular republic embedded in the values of justice, liberty, equality, fraternity, individual dignity, and national unity and integrity. The Constitution is egalitarian. The edifice of the Constitution is founded on the principle of absolute equality. The Constitution promises to secure to all the citizens of the country justice, liberty, equality, and to promote amongst all fraternity, ensuring the dignity of the individual and the unity and integrity of the nation. It recognizes the people as the repository of all power. Sovereignty, of course, is one of the most essential attributes of a state and connotes absolute power to take decisions as permitted by the Constitution, of course, without control from any internal or external authority. In Kesavananda Bharati, Justice Matthews said, the Republic of India was sovereign because it could make or unmake any decision with respect to itself without interference from outside. Socialism, of course, would mean elimination of inequality in status, income, and standards of living. after the insertion of socialist in the preamble, courts interpreting the constitution would lead in favor of nationalization and state ownership of private company, equal pay for equal work, etc. And this has been done in cases pertaining to coal mines nationalization act. In the Vinaba Bill's case and many other cases. But with the new economic policy of liberalization, there may be some clash or conflict with the word socialist, which has been incorporated in the preamble to the Constitution. Now we come to secularism. What is secularism? As per standard dictionaries, secularism means not spiritual, not concerned with religion, a system of belief which rejects all forms of religious faith and worship, or irreligious, so on and so forth. But very interestingly, the Constitution of Bangladesh, enacted in 1972, 4th November 1972, after Bangladesh became independent, starts with the words in the name of the Allah. It says that it's an Islamic state, but there is a provision which says it is a secular state with a guarantee of equality to Hindus, Buddhists, so on and so forth. So even secularism could have different meanings to different persons interpreting the expression. In the context of the Indian Constitution, the definition of secularism as attempted by Smith would perhaps be apt. He says, the secular state is a state which gives individual and corporate freedom of religion, is not constitutionally connected to any particular religion, nor does it seek to promote or interfere with religion. A secular state deals with an individual as a citizen, irrespective of his religion. In Siauddin Badhanuddin, Bukhari versus Bijmohan Ramdas Mehra, Justice Beg said, the secular state arising above all differences of opinion attempts to secure the good of all its citizens, irrespective of their religious beliefs and practices. It is neutral in extending its benefits to citizens of all castes and creeds. So what is contemplated is happy harmony and synthesis between the different religions. In our country, anything pernicious and exploitative cannot be allowed to remain outside the control of law, only because it is paraded under the garb of religion. It is now well established that the state can interfere even with the secular affairs of religious institutions. And in many of the southern states, at least in Tamil Nadu, most of the temples are managed by the government through a specific department. The Hindu religious and charitable endowments. In S.R. Bomai, the Supreme Court held that secularism was a basic feature of the Constitution and upheld the proclamation under 356, Article 356, imposing precedents known in the BJP states in the aftermath of the Babri Masjid demolition in 92-93. The judgment was delivered in 93 or 94. Now, democratic republic, of course, we have a presidential elected head of this. The president is the elected head of the state, and the government is constituted by the people through a process of election. Now, what exactly is this justice which is talked about in the preamble? Justice means harmonization of interests between individuals and groups on the one hand, and the interests of the community. The preamble places justice first before liberty, equality, etc. So it is the entire Constitution is oriented towards securing justice. The principles which have been embodied in the preamble have been elaborated in the fundamental rights, where you have Articles 14 to Article 18, which are the equality clauses. Article 19, the freedom clause. Just a minute, don't turn it this side, papers will start flying. Unlike the kids of these days, do I use a computer? I'm slow in using the computer. So after a while, when I find the time is running out, I switch on to scribbling and scripting on pieces of paper. Then, of course, we have the right to life guaranteed under Article 21 of the Constitution of India. We have the right against exploitation, right against being trafficked, the right to freedom of religion, the right of minorities to establish educational institutions of their choice, and so on and so forth. Dr. Ambedkar had, in the context of the Constitution, in course of the debates in the Constituent Assembly, remarked something to the effect that even a bad constitution can be a good constitution if the people who are responsible for operation of the Constitution are good. And even a good constitution can become a bad constitution if the people who are responsible for the operation of the Constitution are incompetent. Now, here comes in the role of the judiciary. For a healthy democracy, We must have a strong, independent, impartial, and well-organized judiciary. An independent, strong judiciary prevents the arbitrary exercise of governmental authority. It also guards the rights of citizens. In our country, our judiciary is said to be the guardian of the Constitution, protector of the Constitution, so on and so forth. As we all know, one of the characteristic features of several constitutional systems in the world and also of our Constitution is the doctrine of separation of powers. This doctrine envisages demarcation and distribution of the powers of the legislature, executive, and the judiciary. I need not go to the history, which dates back to long ago because of the paucity of time. But it would be apt to quote from Montesquieu's Spirit of Laws. Montesquieu said, when the legislature and the executive powers are united in the same person or in the same magistrates or body, there can be no liberty. Again, there is no liberty if the judicial power is not separated from the legislative and executive powers. Were it joined with the legislative power, the life and liberty of the subject would be exposed to arbitrary control, for the judge would then be the legislator. Were it joined with the executive power, the judge might behave with violence and oppression. This would be an end of everything if the same man or the same body were to exercise the three powers. In India, the demand for separation of the judiciary from the executive was a reaction to the judiciary, which combined two functions to suppress the Indian national movement. Raja Ram Mohan Roy, Dadabhai Naoroji, and others spearheaded the cause of separation, and associations were formed in Bengal, Bombay, and Madras. The movement gained momentum with the spread of education. In 18 Congress adopted a resolution to take up the matter in a serious way. Public opinion about separation was so strong that the Constituent Assembly had to adopt the doctrine of separation of powers. So Dr. Ambedkar proposed a new Article 39A to the draft Constitution, which later became Article 50, which is part of the Directive Principles of State Policy. After the enforcement of the Constitution, the role of the judiciary has undergone a change. We have Article 32 incorporated in the Constitution, under which the right to approach the Supreme Court in case of violation of a fundamental right is in itself a fundamental right. The High Courts are clothed with wide powers under Article 226 of the Constitution of India to prevent breach of fundamental rights, legal rights, or other forms of arbitrariness. The constitutional courts, the high courts, and the Supreme Court are the interpreters of the Constitution. They are the protectors of fundamental and other constitutional rights. Although many textbooks refer to the High Courts and the Supreme Court as the constitutional courts, I personally feel that all courts are constitutional courts because they owe their existence to provisions in the Constitution of India. And much contrary to what is thought, even the district courts may be required to interpret constitutional provisions in the course of hearing proceedings. Now, with powers of judicial review, the courts have been interpreting various provisions of the Constitution of India. A comparatively recent development in the judicial field is the emergence of what is criticized sometimes as judicial activism. The word activism is derived from the word activity. The word active means involved in something. Its antonym would be inert, inactive, tardy, lethargic. Activity is a state of things happening. Economic activity. We refer to economic activity where there is a lot of business going on. We talk of political activity. Activist would mean a person who works for a cause. And judges do work for the cause of justice, to secure justice in accordance with the Constitution, as per their interpretation of the Constitution. The judiciary cannot afford to be lethargic or inactive. It is expected to be active. Innovation and change for the better is always welcome. Of course, the judiciary should take care to ensure that it doesn't exceed the limits and enter into what is described as judicial overreach. It cannot take up administration altogether, but it should definitely be active. To quote Justice P.N. Bharavati, judicial activism is nothing but another form of constitutionalism, which is concerned with the substantivization of social justice. It tries to free the judiciary from the constraints of traditional judicial processes in the interest of social justice and calls for a more dynamic interpretation of the social values enshrined in the Constitution. Considering the lexical and common reasoning of activism, every judge is or should be an activist. To quote Justice Krishna Iyer, every judge is an activist, either on the forward gear or on the reverse gear. Judicial activism is something which is not totally new. Way back in the 90s, in the case of an undertried who could not afford a lawyer, the question was whether the court could decide the case by perusing the papers. Justice Mahmood held that the case could be said to have been heard if someone spoke. Now, this activity of the judiciary can be of two types, either in support of legislature or executive action, or in opposition to them. However, it is the activity in opposition to legislature or executive policy decisions which is generally criticized as judicial activism. In my view, in a sense, judicial activism is the rendering of decisions which are in keeping with contemporary thought. Judicial activism secures justice, the liberties, equality, fraternity, as stated in the preamble, and elaborated in parts 3 and 4 and other parts of the Constitution. Now, please tell me when I have to stop. How much more time do I have? 10 minutes. Okay. I shall sum up in 10 minutes. In the recent past, we have had relatively recent past, I must say. It may be recent for old fogies like me, but not so recent for those of you sitting before me. The other genre of litigations is the public interest litigations, which have emerged. Now, where the rights of a citizen or a group of citizens, or a group of persons, I should say, is breached, and the person has no access to court, then any person can file a public interest litigation. The courts are liberal about the locus standi. But of course, even in a public interest litigation, the courts have to proceed in accordance with law. Now we quickly look at what the judiciary has been doing and how the judiciary has been interpreting the Constitution from the inception till today. I will be very brief. I'll just refer to 2 or 3 of the major judgments. In the initial days, there was not much conflict. The conflicts were restricted to the right to property because attempts were being made by the government to introduce land reforms. There were disputes with regard to compensation. The laws were challenged on the ground of inadequacy of the compensation. And the courts had been interpreting the Constitution, constitutional provisions, in some cases granting relief, but holding that the provisions were not amenable to challenge. The challenge to the provisions were rejected in most cases. So we have the case of Kanishwar Singh, followed by Sachin Singh. In the case of Bannerjee, however, The Supreme Court said the compensation cannot be illusory. But the amendment was nevertheless not interfered with. The trouble started with Golaknath in 1967, when the Supreme Court held that the fundamental rights could not be amended. Then came Kesavananda Bharati, which reversed Golaknath, but introduced the principle of basic features which would remain unamendable. We also see a positive change in the view of the Supreme Court. In A.K. Gopalan, in the case of A.K. Gopalan, Supreme Court was of the view that Section 21 only gave protection against executive arbitrariness. The arbitrariness of a legal enactment would not be questioned. But in the Maneka Gandhi case, the Supreme Court took an altogether different view. One of the areas where Supreme Court has, and also the High Courts, have exercised their power of interpretation is in the field of Article 21 of the Constitution of India, which reads, no person shall be deprived of his life or personal liberty except in accordance with procedure established by law. Today, that provision, if that provision were to be interpreted literally, it would just mean that a person cannot be deprived of his life, his physical life, or his personal liberty, except by recourse to a law enacted by legislature. But that provision has widely been interpreted by the Supreme Court to mean that the right under Article 21 means the right to live. The right to live includes the right to live with dignity. It includes the right to shelter. It includes the right to health care. It includes the right to a clean environment. It includes the right to speedy trial. It includes the right to fair trial. You name the human right, and you will find that there is a judgment of court which says that it is part of Article 21. And then, of course, more recently, we have judgments upholding the right of privacy as a fundamental right. The adultery provision has been struck down in Joseph Schein as discriminatory because it discriminates between the man and the woman. The wife is treated differently from the husband. Then Article 377 has been struck down. Many women commissioned officers, in the case of Bhavila Punia, the Supreme Court held that they would be entitled to appointment, given the permanent commission. So if there is a healthy judiciary, we can give meaningful effect to the constitutional provisions. Just 2 minutes. It's just 100 pages. To quote S.P. Sathe from his book, Judicial Activism in India, Transgressing Borders and Enforcing Limits. Judicial activism is not an aberration. It is an essential aspect of the dynamics of a constitutional court. It is a counter-majoritarian check on democracy. However, judicial activism does not mean governance by the judiciary. It must function within the limits of judicial processes. Within those limits, it may either uphold and legitimize the action of the other organs of the state and strike down their action. We still have a long way to go, but I think we have made a good start, and we can hope that we will be able to achieve the objects of the Constitution and also our future. Thank you.
Thank you, Honorable Justice Indira Bannerjee. Now, we will move on to the interactive session.
Start with asking my own conclusion. Mr. Bannerjee said that Indian Constitution is very clear. And certainly judiciary has done a lot to set laws to promote women's issues. What has troubled me all these years is that why is it that the Indian judiciary did nothing? Till date, almost nothing, but they're still struggling to deal with it. When it comes to personal law and all the discriminatory provisions that is committed, why is the Indian judiciary still not born ahead? Instead, the interpretation given so long ago in 1962 by this is really because we want in High Court, saying that because personal law is not mentioned in Article 13, therefore personal laws are outside because of Article out of the state. And by that judgment, which is only a High Court judgment, till they the judiciary not said no. Either personal is a law or it's not a law. So if it is a law, this is qualified by personal, it does not become that it is not a law. So by that one judgment, we have excluded women from the constitutional guarantee of equality.
There have been personal laws which do violate Article 14 in my view. Now, what I say here is, of course, my personal view. I can give you one example. The Hindu Succession Act. It was amended in 2005-2006 And women were even given the right to joint family property, which they did not have earlier. They were also given the right of partition. The law as it stood there took away what was given to the woman by denying them the right to seek partition if they happen to be married. Only a divorced woman, a single woman, or a widowed woman had the right of residence. And the right of residence can never be the same as the right to ask for partition. Today, there is still a problem. In enacting the law, legislature has proceeded on the basis that it is the girl who leaves the parental home and goes to the matrimonial home and becomes part of the matrimonial family. It still proceeds on the basis that most women, their income would either come from the husband or from the father. So if the woman dies childless, then property inherited from the father will go to the father's heirs, and any other property would go to the husband's heirs, because it proceeds on the basis that she becomes part of the matrimonial family, and whatever income she has is assumed to be from the matrimonial family. But the law definitely needs to undergo a change. I think somebody will have to file a litigation. Some women's group.
Many a time, husband challenges have been made, but they have not been accepted by the judge. So it should actually be justice.
I think in view of the recent developments in various areas, an attempt can once again be taken. But yes, it is discriminatory against women, because there are many women who have income which is entirely their own, neither inherited from parents.
In that sense, the judiciary is actually not followed the vision of the Constitution. In your opinion, is women free?
When I was giving my speech, I mentioned the doctrine of separation of powers. So it is the legislature which has to enact the law. The judiciary in a given case can hold that the provision is discriminatory.
So when we're questioning that Article 13, where it says that any law which is contrary to fundamental rights is void. So by that one judgment, if they don't have that exclusion, by the judicial interpretation, that we actually violate the Constitution. It's not the legislature law, because legislature comes later, but the Constitution says that all laws which are violating of Article of fundamental rights are void. So all personal laws that were discriminatory should have become void from that point onward. But by
It has to be declared. It has to be declared void by a court of law, otherwise it is presumed. A law enacted by legislature is presumed to be valid unless it is held invalid by a court of law. And the court doesn't do its homework. Yes.
Due to paucity of time, we'll take 2 more questions.
Can you please come forward? Yeah.
Thank you.
Ma'am, my question is regarding the definition of secularism that you mentioned. So, ma'am, in my opinion, the definition in the context of the modern world, the definition of secularism shouldn't it be extended to a system where the state actively protects the free practice and profession of a religion, instead of just saying that we allow any individual to profess that religion. Because of all the minority oppression that exists today, shouldn't the state take an active role in protecting the profession?
If the attention is drawn to interference, then the state will take an active role to prevent it. You have to lodge a police complaint if somebody is interfering with your right. It depends. It also depends on what they are interfering with. Because the courts hold that freedom of faith, freedom of worship, that is guaranteed. But so far of practices in the garb of religion, they cannot escape the control of law. So it depends on what you want to do. Now, if somebody wants to take out an immersion procession down a particular street, and there is a police order preventing the procession from going down a particular street, I don't think that should violate the freedom of religion in any way, because that is not an essential religious practice. But if any person's essential religious practice is being interfered, the right to enter a temple, the right to enter a mosque, the right to go into a church, then there is remedy open to such a person. He's asking a question.
So, yeah, we'll go to the next person, please.
Yes.
Good evening, Justice. Justice, my question is regarding marital rape. There have been recent cases where the High Court recognized marital rape on the ground of divorce, and in certain cases, the court recognized it as a ground for abortion and recognized it under cruelty, basically. So, Justice, what is your stance on criminalizing marital rape in India?
That again is for the legislature to decide.
All right, if I may follow up. Justice, why is this discrimination against married women?
What discrimination against married women?
Under Section 375, why are they left out from the purview of rape?
Married women are not left out from the purview of rape.
If it's
Only so far as the husband is concerned.
yes.
That is because if a woman is raped by anyone, she has the same remedy.
Except for them.
That is because the assumption that a person gets married to have a family and physical relationship is an integral kind of marriage. No, sir, no one can. It is definitely wrong. I'm not supporting marital rape. Certainly not supporting marital rape. But it's been kept. The legislature in its wisdom has kept it out of the purview of a penal offense. Because marriage is sort of a license otherwise.
Thank you. Okay, so this will be the last question.
I want to ask questions which are in the purview of the legislature. And in the purview of legislative wisdom, ask something with regard to the law, you'll get an appropriate answer. Yes.
My question is like, provided that if the issue comes, like let's say in PIL or let's say anyways it goes to Supreme Court in the purview of Article 21, when a person says that a girl, a married woman, she has body autonomy, she has right to life and personal liberty, then right to equality would be raised under Article 14. And in lieu of these both articles, because 375 again has that provision where, like for the married girls also, the 15-year age gap is there. So ma'am, under all these purview, if everything has been like raised properly, in that case, can women get protection? Married women can get protection from marital rape from court's judgment, because obviously the arguments are there
Under the Domestic Violence Act, yes, protection of women against domestic violence. Marital rape is a form of violence, certainly.
Yes, ma'am, I completely agree. I'm just asking that in that scenario, will court will be in a position to declare like marital rape as a rape when these contentions are being raised?
It's pending in the Supreme Court and court. Yes.
Thank you. I now request Srimati Abhipsa Das, Managing Trustee, and Ipsita Pujari, Trustee, Swayam Prabha Foundation, to come forward and present a memento to Honorable Justice Indira Bannerjee as a token of gratitude.
We can come from.
Thank you, ma'am. Before we conclude this event, let us express our gratitude to all the dignitaries and guests who made this event possible. May I now request Professor Rangeen Pallab Tripathi, Registrar, National Law University, Odisha, to kindly deliver the vote of thanks for the evening.
Thank you, Shivani. Uh, I'll begin by thanking the person who got all of us into this room at the same time together. First of all, thank a lot to Mrs. Indira Bannerjee for agreeing so kindly to come to NLUO with us physically and for choosing such an important topic to deliver this after your second visit. And for choosing such a brilliant topic, which is contemporary and perpetually relevant, and for delivering the lecture. Thanks a lot to you, ma'am. I am really thankful to the family of the late Ms. Sailabala Pujari, starting with the late Mr. Govardhan Pujari, who was instrumental in setting up this entire memorial lecture series. Her daughters, Ms. Anusa Das, Managing Trustee, Ms. Uchita Pujari, Trustee of the Foundation, Dr. Nandita Pujari, Advocate Supreme Court of India, her grandkids, Ananya, Hariprasad, Satakshi, and Nesargit, who have been involved in this entire process. We have many foundation lectures where people give us a donation, people give us an endowment, and they leave everything to us to organize. But it's really heartening to see that the family is so involved in preserving the memory of such a historical personality. Much of history is forgotten because we ourselves do not remember it. So thanks a lot to the family for taking such efforts to keep that history alive, to keep reminding us how rich the state has been in relation to personalities who have done terrific things. So thanks a lot to the entire family. And my extreme gratitude to all the honorable judges who have graced with our presence today, starting with Justice B.R. Sarangi, Justice Kalpatra, Justice Narasimha, Justice Raman, Justice Achikant Mishra, Justice S.K. Mishra, Justice Sangam Sahu, Justice B.P. Rautray, Justice Aditya Mahapatra, former Judge Justice K.K. Paricha. I forgot entirely, and so sorry when I spoke about the family. The eldest son-in-law of Ms. Sailabala Pujari, Justice Chittaranjan Das, who have been extremely instrumental in following up. He has been contacting me every other day, following up on what progress has been made on organizing the event. Thank you to all the spouses of the judges who have made it here. Thanks a lot to the faculty members, my colleagues who have been extremely supportive whenever we have called upon them to help us in organizing this event. They have been there. Sorry, I'm really sorry for God. Mr. Sabitra, who is present here today. Thanks a lot to that as well. To the students who have come here in such large numbers, generally we have to coerce students a bit to come here. But I was very happy today when I was walking the corridor. There were so many students from 5th years, 3rd years were coming here voluntarily. And that shows the genuine interest they had towards the lecture. And lastly, again, I'm so sorry. I'm forgetting names and really apologies. I again thank Justice Arindam Sinha for being present here, and our Advocate General, Mr. Ashok Parija, who has been so kind to be with us. Lastly, I would like to thank Mr. B.P. Rautray. Lastly, I would like to thank the silent engine for any of these events, our administrative staff, starting from our staff in the registrar's office, who help us arrange everything, the staff from the IT department, student volunteers who were put in a great deal of work in making such success, And like I forgot in the middle of the vote of thank some names. If I've forgotten any more, that's all mine. This is so if I've forgotten any other names, that fault is completely mine. And thank you everybody for coming here today and making this event such a grand success. And I would request all dignitaries and invited guests to please proceed to the next room where we have arranged for it. Thank you.
And